Back in the 1930s, if you owned a car dealership, you didn't have much leverage. The manufacturer could ship you cars you never ordered, cancel your contract with no real reason, and without much recourse. So states stepped in and passed laws protecting dealers, guaranteeing their territory, protection from getting dropped without cause, and the rule that manufacturers had to sell through independent dealers, not compete against them with their own factory-owned stores. That rule is still on the books in every state today, and it's impacted the direct-to-consumer model that new manufacturers have been fighting today. Those laws were written to, sort of, referee the relationship. Manufacturer and dealer, two sides negotiating. New manufacturers like Tesla, Rivian, and Lucid never had that relationship. No franchise dealers, no territory or contract to protect. In Massachusetts, the Massachusetts State Automobile Dealer Association attempted to block Tesla from selling cars in an auto mall. The state Supreme Court ruled that the existing dealers suing Tesla didn't have standing to bring the case, because the law was written to protect dealers from their own manufacturer, not to govern a company that never had dealers in the first place. Not all states see it the same way. In 2014, New Jersey tried to block all Tesla stores, and at first, the state's Motor Vehicle Commission ruled that any new dealer had to go through the franchise model. Tesla continued to fight, and the legislature eventually settled on a compromise. Tesla could keep operating, capped at a set number of stores. The state of Michigan enforced its existing law and kept the direct sales model out entirely. And in Connecticut, the Dealer Association actually won in court, shutting down an existing Tesla showroom in 2019. Tesla later partnered with the Mohegan Sun Casino, which is on sovereign land, and opened a location there. Because the property is tribal land, it is exempt from state franchise laws. Today, the result is a patchwork of rules across the country. Roughly a third of states allow direct-to-consumer sales. Roughly a third ban it. The rest sit somewhere in the middle, allowing it, but capping how many stores a company can open. And because most of these laws define manufacturer broadly, instead of naming Tesla by name, other manufacturers like Rivian and Lucid inherited the same protections, state by state, without even going to court themselves in some cases. Slate, when it starts deliveries, will also use the same model. The next case test is Scout Motors, an EV brand owned by the Volkswagen Group. Volkswagen already has franchise dealers for its other brands, but wants to sell this particular brand direct to consumer. One of the questions is, do the existing Volkswagen franchise relationships garner protection in this case? That's a different legal question than the non-dealership manufacturers had to answer. It's still working its way through the courts. A new wrinkle. One a lot of people will be watching. One that could impact almost a century of existing laws. What do you think of where the franchise laws today? Put your thoughts down below. Subscribe and stay current.